Okay, so let's commence. Hello, everyone. Welcome to our second Decoding Legal webinar from our webinar series that is brought to you by Sparring and supported by Project Catalyst. I am here again as for the last time, and today I will hand over the I will hand over the mic well online so to my colleagues Matteo and Martina, who will be presenting to you legal essentials for Cardano Founders Part 2, and will explain to you the topics that you hopefully will find very useful today. And after this webinar, I will share with you the feedback form. So we'll be more than happy to get any feedback and let us know what you want to see in the third webinar as well. And without further ado, let me hand over the mic to Matteo. Please go ahead.
Hey everybody, thank you for joining live or watching us from a recording. So in the previous webinar, you have covered your initial choice of jurisdiction, the legal, tax, and regulatory questions for choosing the right place and corporate structure. Today we'll follow up and cover the things that you'll be doing just after your corporate formation. So setting up the team relationships, basic governance, contracting with teams, setting up ESOPs, and then we'll finish up with talking about fundraising. Given that this is a rather broad overview, we'll only provide the basics for most of the topics, walk through the main things that you should think about, but feel free to explore deeper, ask questions, or contact us if you're curious about more. So I'll move into articles of association right away. So first of all, what are these? This is your main foundational document that you will be signing for practically any entity that you're forming. Essentially, any type of entity that you've discussed in a previous webinar has some document that works akin to articles of association and sets up the basic governance structure of the entity. There are a few main things that you should always include and think about when forming and writing your articles. So first of all, you'll be talking about the share and governance structure. This can mean actual shares in companies such as corporations or the more classic forms, or in cases of tokenized equity or working with foundations, this could be the on-chain governance and how it is projected into the actual off-chain entity. This is also tied to voting rights and governance. So this is the document where you will decide, for instance, who has how much voting power, whether your main governance token has all the voting power and everybody holding one token has one vote in the actual corporate entity, or whether the governance token has a certain voting percentage and then the rest is left to the founders, or it's all governed by a board. So there's a lot of different voting mechanisms and governance structures that you can set up here. And the articles that you're writing when you're forming the company or the other type of entity are the place where you do that. Same goes for any governance bodies. So what we most often see is that in sort of more standard companies and sort of startups that deal with Web3, we see classic boards of governors or boards of directors and management. However, if you're doing a project that is more decentralized, it's sort of either DAO based or in a sort of more lean and sort of decentralized token-based structure, then we could be talking about governors or people who are responsible for maintaining the protocol. These could be validators who each hold some governance power. And there's a lot of freedom with many corporate structures, I believe, as was discussed in the first workshop, where you can pick and choose your governance and create it really to suit your needs of the specific projects. And then the final two very important points, and this is sort of the crux of what you need to think about, is transfer rules. This is the place where you can set up the rules for transferring either shares or some sort of a phantom token scheme within your company. This is where you can say that the founders cannot transfer their shares without the consent of the other founders, or your advisors can freely sell their either off-chain representations of tokens or actual shares without your consent. This is where you make sure that people cannot trade off their interest in your project to random third-party people that you know nothing about, and where you can create some security for yourself. And then same goes for aligning the structure with your DAO governance. Like this is where the articles are the place where you can very nicely align the off-chain corporate world with your DAO governance, the protocol governance that you're working on, where you can often transform your DAO charter or DAO governance documents into real-world legally binding documents in the articles. And that can be a lot of creativity that you can engage in here. So we highly recommend that you think about this document and just make sure that it actually works with what you do in your project. So then moving on to founders relations. And by the way, at any time, if you have any questions, feel free to drop them into the chat, or we'll of course be happy to answer them at the end. So for founders relations, this is the next absolutely core step that you'll be dealing with. Oftentimes, and this is the important part, you might be dealing with founders relations even before you form your company. Because the company formation, that's the very legal and technical part. Founders relations and the team relations we'll cover afterwards. This is the human part, where it's less about the legal and more about thinking about the business. So it's when you're starting off your project, I'll first cover what you should think about, and then how you can sort of legally transcribe these, make sure that these are actual legal contracts. First and foremost, what's absolutely the most important part is assigning the role and some KPIs, or like key performance indicators, to each founder. Like we have seen too many times that in like very decentralized crypto teams, the founders didn't really understand what each person's role is, what their responsibilities are, and this caused a lot of disputes down the line. So really just sitting down on a call or in an in-person meeting and discussing who has what responsibility, what their title is, and what they should do on a day-to-day basis is super helpful. So step one, write this down. Then you can get into the more technical parts, and there's a lot that you can cover. Like the decision-making authority, like who can do what for the project, the token or share allocations that you're getting, and the vesting conditions. And so all of these, there's a lot of technicality. It really depends on what your particular needs are. But what I want to get to are the vesting conditions and good and bad lever provisions. What we see very often in early stage Web3 projects is that, well, everybody starts off as friends because you're all excited about the project. Well, you wouldn't be starting the project if you weren't excited about the project and the team. But as time goes on, the complexity increases, maybe people fall out, the relationships break down. It becomes, at some point, it usually becomes difficult. Like you almost every founder of any crypto project will be struggling at some point. And therefore, vesting and good and bad lever conditions are what comes in. If someone wants to leave the team, they're done with the project, or the rest of the project decides to terminate them and say goodbye to one of the co-founders, vesting is what governs how much of their initial tokens or shares they can retain. So for example, what you can do, what's a very classic vesting provision, is that you do a 4-year vesting, meaning that your shares or tokens are split across 4 years. And if you are terminated or leave after 2 years, you get half of your tokens and you have to return the other half. If you stay for the entire 4-year period, then you get all of them. And this is a crucial provision that I have seen save so many projects in the past when we were working with either off-chain or crypto-based startups, because this is what ensures that people leaving the projects don't take away massive amounts of your tokens and equity, and really allows you to continue with the project even with a new team or if some of the co-founders leave. And this can be tied to the good or bad lever provisions, meaning that you determine if the person is leaving as good, someone who helped the project, or someone who was terminated because they didn't do well or left on bad terms. And this can have different consequences. They can keep different amounts of tokens, for example. So this is really, if there's something in terms of founders relationships that you're actually thinking about when setting up your project beginning, maybe after you've just received your first Catalyst grant, it's the roles and KPIs of everybody, and then the vesting and good and bad lever provisions. Like this is something that you should sit down and talk about before you start anything. And why is this important? Other than just, having clear rules and understanding between your team, we see that having clear team setup and founders relationships truly helps token holder confidence And when you're dealing with more sophisticated token holders who have invested or have been parties to several DAOs and projects before, for them, understanding the governance, understanding your founders' relations, seeing that everybody's covered by vesting provisions, for example, if they have substantial amount of tokens, it really boosts their confidence and shows them that this is a project where people are taking it seriously and where they know that the risk of half the tokens just becoming dead weight that no one controls, for example, because the founder left, is that this risk is decreased. Same applies to investors. If you're thinking about if you've just received your grant, but you're thinking about getting more investment in the future from other parties, this really helps get investors on board. But it of course helps to protect your projects and prevents deadlocks and just those debt equity, debt token scenarios. So truly helpful to think about this. And then just very quickly covering on well, now that you've sat down, you've had your call, and how do you actually agree on this? Like, what's the best place? So there are a few methods that you can choose here. First one, in a founders agreement. And this really can be absolutely anything. We have founders coming to us and asking us, like, can you give us a good founders agreement template? We sometimes can provide something, but this document can really be anything. Basically says the four of us each signing at the bottom agree to these basic terms. We will each contribute this and that. These are our roles. This is how many tokens we get. These are the vesting terms, and we all agree that this is what will be governed by. It can be as simple as that, and it can really help you down the line. And then, of course, you can set out these rules in a shareholders agreement. If you're dealing with an actual company with shares, like a corporate structure, like a corporation, LLC, or a local equivalent, wherever you are, you can have this in the shareholders agreement or in your ownership agreements. And I've used the term ownership here because we didn't know what kind of company you'll be working with. But if you're purchasing shares or like a membership units or some sort of a phantom token units tied to a foundation, it can really be anything. There's usually an agreement that governs this, and that says you will be getting a grant of 1 million of these. And in that, you can include these terms and say how the vesting works and what the general role of the person, for example, is that they're doing in exchange for the grant. But this could also be covered in the more general documents, such as the DAO charter or the bylaws of your company. It really depends on the corporate structure. The important thing is there are multiple places where you can cover this to make sure that when you're setting up your structure legally, you find the right place, include these terms, and have a talk about them. And it really increases the chances of your project to succeed. So we'll move to contracting your team, and there I'll let Martina to kick us off on why it actually matters to contract with your team.
Yeah, thank you. Because we simply believe not just only relationships between the founders are important, but also like all the relationships with the team, contractors, and people who are actually building your project or helping you building your projects matter. And there are, let's say, like few key points. Why would you be taking care of this like really, really carefully? Intellectual property is one of the, for me especially, key areas what should be covered because as we see with the technological development of every, let's say, the projects lately, intellectual property is something what your investors in the future would be always asking if like it's really well done, settled between you, your funders, the company itself, and all the team. Also, the confidentiality is one of the key matters what you should be covering when it comes to starting some cooperation with a team member or someone who's helping with the project. And it's simply because those two fields are really, really important when it comes to the value of the company. Because like if someone would be able to, for example, like steal your project and starting to do something very similar, it could be, of course, a huge problem. And I would like to also point out that I know that especially from the start of the project, usually people are working like, we are friends, we have a good relation, we don't have any paper right, but this is really something what I wouldn't recommend ever, because even between the friends, relationship can go wrong, and having a paper stating like what's your expectations, what's your KPIs, how intellectual property works, and how all the other, let's say, matters or terms are settled, it's always the best for your protection. When it comes to taxes, I would maybe give the word back to Martin, because it's his area.
Happy to take that over. So yeah, this is a topic that always bores people, so I'll be very short on taxes and compliance. So it's very unlikely that you will ever be going to court with any of these team contracts. Like it's probably very, very unlikely that as someone developing an interchain bridge from Singapore, for example, you will be suing your developer who sits somewhere in either California or somewhere else because you don't even know where they are. Like, you're probably not going to court. But the reason why you would want to have that agreement in place, for example, is to say that this person is a freelancer working for the team on a contract basis and is not an employee. Because if someone found that they are an employee, or if they then claim in and said, well, I'm an employee of your project, I'm working for you every day, then this could cause significant tax and compliance issues for you. If you're contracting with a team of, let's say, later down the line, 10, 15, 20 people, they're, as we see with most crypto projects, they're spread out in at least 5 countries. If all of them suddenly started claiming that, well, I'm an employee, you have to treat me like an employee, then this could cause very, very significant tax and compliance issues for you. And we've actually seen this with larger DAOs contracting larger teams, especially in times of economic difficulty, when they were terminating people started to ask whether they shouldn't be getting specific employment rights. They shouldn't be why didn't they pay like social security contributions for them? Because, well, they thought that they were employees. And we had to do a lot of work on explaining why this wasn't the case, what the relationship actually was. And so setting it up properly is very important. And just a final shout out on why contracting matters, specifically for multi-sig operators and treasury managers. This is something that we were dealing with larger DAOs, where the treasury funds are already more significant. But even if you just received your first Catalyst grant, there's a treasury somewhere that holds a not insignificant amount of money, fiat money or tokens. And there's someone who then actually, helps make the decisions, either one of the people holding the multi-sig keys, or the person managing treasury, making investments, just making sure everything works as it should, that your funds are protected. These people are taking a lot of risk and liability. And for these people to be able to sleep at night well, it's very good for them to have a contract which says that, well, they should be doing the best they can. But if there's some unforeseen circumstance that they absolutely couldn't have prevented, they are not responsible for the damage that is caused. Like if someone, despite doing all they can, if someone hacks them and gains access to one of the keys, manipulates the others, and then somehow gets access to the treasury, or if they make a trade with your treasury funds and that trade really backfires, even though it seemed like a good choice, it's very good for them to have a contract which says that they will not lose their house if this happens. So, highly recommended to think about that, whether you're a founder or in a position of one of these people. So moving on to the forms of cooperation.
Yeah, what can you do basically when you're starting cooperation with your team? First of all, I would recommend to kind of think through what type of contract would you be preferring? Because it really matters sometimes, and sometimes not, and sometimes it fits to like this scenario, but not the other one. Employment is kind of like standard form of cooperation between the company and the employees. It has like some kind of more strict rules across I would say almost all the jurisdictions, because let's say simply employees are more protected by the law itself. When it comes to freelancing, you can use like so many type of contracts, like let's say the contract for provision of the services, some contractor agreement and stuff like that, based on either the project or like the continuing provision of the services. What's the main difference between those two? I would say it's more like a liability of the employee or the business contractor towards the company, because when it comes to employment, the liability is always limited. So this is also the thing you should be thinking through once you're choosing the contract. And also, there is one more issue when it comes to choosing between the form of contract. In certain jurisdictions, for example, there is prohibited to replace the employment by the freelancing contract, when it should be like a hiding the form that it should be originally employment, but like you want to save some, let's say, costs on an employee, so you offer them freelancing contract. So I would be really careful when it comes to jurisdiction, which you are like where you are choosing the form of cooperation. Of course, if you won't be doing any of those, I would definitely recommend at the start have at least NDA agreement when it comes to confidentiality of the information of the project, and maybe some slight IP clause regarding to the project ideas and intellectual property related to it.
Yeah, and really just doubling down on this. Employment is difficult. It's very, unless you become very, very big, it's very unlikely that you will have employees in most projects. But at least having someone who develops, I don't know, for example, someone who develops your core solution or works on your core tokenomics, for example, having them as a contractor or freelancer really helps to protect your company. And in case you're very, very early and you don't even have your company started yet, it's good to maybe have an NDA, an IP assignment just with you as a team. It's questionable to what extent this is enforceable, but at least if there's a simple written template that says that everybody will keep secret about this, we promise this to the other founder or to the project, and we also give to the project or promise to, in the future, if there is a company, give to the company all of the intellectual property, so the code, the UX, the graphics, whatever you're creating, like whatever we develop, we promise to give it to them. Then that can be very helpful, especially if this person leaves and you're trying to continue the project without them and don't want them to fork and try to start competing with you, create something that looks very similar. So it's good to take care of this. And then finally, talking about sort of two more creative solutions here. So first of all, employer of record companies. And this is something that it's difficult to say whether it is legal in the jurisdiction where you are. The laws here are very mixed, but there's a lot of large companies such as, there would be like Deal, Remote, or similar companies that offer to employ the person for you, act as their employer, and you're just paying them a monthly fee for doing that. That can be very helpful. If the people that are working with you want more security, if you really need like top-tier Web3 developers to develop your project and they require actual contracts and just to actually have some security, then this is potentially a good solution. And then finally, token grant agreement. We've seen this when teams were working either with individuals, or you can maybe use this, well, maybe you can use this even with teams and maybe small software studios that are working with you, when you make a simple contract that says, we are granting you X amount of tokens from our treasury, and in exchange, these are the services that you are providing. So it's close to a service agreement, but it looks like a token grant, which can be very beneficial for many projects working as DAOs. And it also promises that you will get some value for the grant that you are making as a project, a DAO protocol, whoever, to the other party. And the party has some actual legal obligation to give you something back. So it's very useful to work with these. And so then we'll quickly go through employee stock ownership plans, and I'll get to why they're relevant here. So first of all, employee stock ownership plans are ways in which you can give parts of your project to your team members. The important note here is they don't apply just to employees. Employee stock ownership plans can apply to your contractors, to people who don't even, in many jurisdictions, don't even really have a contract with your team, to advisors, anyone working with the team. And they don't always apply just to stock. With Web3 companies, it's very common to do blended stock and token plans, or just token plans. So the name is a bit misleading, but the employee stock ownership plan or the ESOP is just what's used, but they can really be a token-based incentive scheme for your contractors, for example. Of course, the core issues and the core things that you're doing here is motivating the team, saving you either fiat cash or the more liquid tokens that you have just received. But just do note that in many jurisdictions, notably, especially in the US, and to some extent in continental Europe, these are regulated and they can be taxed. So you have to be careful. Just ideally consult a tax advisor when you're structuring an ESOP. But just to make sure that we were on the same page, the way a properly created ESOP, and I'll get to what that means, works, and is different from just paying someone in tokens, is that instead of saying that you will get X amount of tokens per month or per hour that you work for me, you say that you will get my special governance token, which I hope will have significant value in the future, if you work for me for at least some amount of time. Vesting applies. Maybe if you meet these specific KPIs, and you will not get them now, you will be getting them in the future as we are developing the protocol. And this ensures that you long-term motivate people to stay with you. And so what are the core mechanics of setting up an ESOP or a token incentive plan? Let's call it however we want to. So first of all, you have to decide the percentage of your either equity or tokens that you want to reserve under the plan. And this is, believe it or not, quite a crucial term when you're looking for investors in the future. After you are running out of your initial Cardano brand money and you're thinking about taking your project to another level, and you're thinking about getting a crypto VC to join in or get a few safts from more professional investors, one of the things that they might be asking about is whether you have a certain percentage of your tokens reserved under for a plan for your employees and team members. And so doing usually 5 to 20%, but this really varies for the team, of tokens or equity can be very helpful and can show whoever is investing into you in the future that you mean this seriously and want to motivate your team to stay with you long term. And then what you can do, and I'll not get into the details because we've had seminars where we're just talking about this for a rather long time. You can either be granting restricted stock, or restricted tokens, meaning direct grants that the people get right away, but there are some restrictions. You can give people options, meaning they have the right to purchase a share or a token in the future if they meet some conditions. Or you can give them future token interests. And this can be important if you are just developing your protocol, you don't have the tokens minted yet. You might say that this plan says that you have a right to receive a certain number of tokens once we reach the token generating event based on the time that you are with the company, for example, or with the project. And so you can really play around with this and set this up even if you don't have a fully functioning protocol with your governance token yet, and you can still use it to motivate people quite well. And then, of course, once all of this is set up, the next step would be actually issuing the grants to your team members and thinking about how much everybody should get and how they should be distributed. And just as a note here, on the company structures that you were talking about last time, what we often see with sort of more advanced, larger projects is that when they have multiple companies, and for example, one of them is their sort of off-chain operating contracting company, whether that's in somewhere onshore. So for example, very often in the US market. So you'd have this company, and then you'd have your foundation somewhere in the offshore, for example. You'd have an ESOP for the contractors and employees of the onshore company that offers them tokens created by the other company. So you can really play around with this. You can say that our ESOP is based on the tokens created by the foundation and the offshore, and you can nicely motivate your people this way. So there's a lot of room where you can be creative with this and ensure that your team actually gets some value from staying with the team, with your project long term. So now moving to intellectual property, handing over to Martina to cover this.
Yeah, this is my area. So let's go. Let's say there is a huge bubble of intellectual property, right? Like, what does it mean? Like, is it a software? Is it my logo? Is it like my invention? So what should I do once I own something like that, or once company owns something like that? I would like to point out the main difference between all those mentioned categories, where the copyright is, let's say, something where you don't need any registration. It's just something you created by yourself. But what's tricky about copyright, it's this distinction between the form of copyright among the multiple jurisdictions. Because, for example, in continental Europe, when we talk about copyright, it's something what was created solely by the individual human being. It's not possible in most of the jurisdictions that something like that would be owned, for example, by the company. We have like some different means how to acquire, let's say, rights to copyright. On the other hand, you always have to think when it comes to copyright, where the dispute, like from infringement or anything like that, might be happening. Because in that case, I would really recommend that for your contracts with your team or with your customers or anyone would be thinking about the possibility that the copyright infringement won't be happening in your jurisdiction, for example. So in that case, like, you cover more areas when it comes to copyright. When it comes to trademark and let's say patents and maybe some designs, those types of intellectual property are, we call them as industrial rights, and they are only protected once you register them in a certain databases, which are also distinguished by the jurisdictions. So you can, for example, apply for the protection in European Union, in USA, or in like specific state globally, worldwide, like through the respective databases or respective offices. And when it comes to a last one, which is trade secrets, and I usually put those together with know-how to the third specific category of the intellectual property. Those are mostly like protecting of your ideas, of your, let's say, procedures, or something which is not tangible and not really able to be protected by the other categories. So there we need to do like NDAs and some contractual protection for those categories. And I'm not sure, maybe did you want to mention?
Happy to contribute here.
Yeah.
So maybe two things that I wanted to add here. So we included patents. Patents are expensive, patents are complicated, but in the past few years, there were thousands of patents for cryptocurrency and Web3 related technology, especially in the US and China. So this is now becoming crypto related software is something that you can now actually patent, which is quite new. And then the second thing that I really wanted to highlight here is the importance of this. Your intellectual property is the most important part of your project. This is what you are developing. You are spending those hundreds of hours on creating this, whether that's a unique interchain bridge or a unique idea for a new solution within your ecosystem, or maybe it's just a very, very nice UX and a great website and a portal that allows you to more easily interact with the chain. Something you're spending a lot of time on creating this. So it's very, very important to protect this. And as Martina was saying, you're doing this through contracting with your team and making sure that they assign all of the IP to you, signing NDAs so that people have to protect your trade secrets. Or thirdly, and moving on here, for trademark protection, we can do a bit of advertising here. You can do a free trademark check with Trauma TM, one of our partners, where they can tell you for free whether the name of and brand of your project that you're thinking about is available for trademark protection in the future. So it's just good to do a quick check here before you create a website, spend money and efforts on logo branding, start using it, just to know whether it's available for you later on. And moving to fundraising and investors. This slide, it's not pretty. I really tried, but it was difficult to put that together. But this is what you or you should ideally take away when it comes to fundraising. When you need money and you need to pay people who are working on your project, you need to pay for some maintenance fees, so you will need to probably raise money from somewhere again. Just stop and think about the options first. Because what we see is that many people say that, well, we need to raise more money, so we'll go to a token launchpad and raise there, or we'll issue a few SAFTs, for example, or I'll sell a few shares, and they didn't think about the actual options that they have. So when you're a Web3 based project, you have two options: raising through tokens, that's the left side, and raising through shares and off-chain assets, that's on the right. And then you also have always two alternatives, whether you are selling now, so you're selling your tokens now, or offering some future rights. So there's a lot of options and combinations, as you can hear, as you can see, but maybe I'll highlight, well, the two most important ones. So in the crypto industry, SAFT has become an absolute norm as a simple agreement for future tokens. So this is a very, very good instrument that you can use as an early stage protocol if you just need to raise that extra few thousand, for example, although we've seen safes for millions, SAFT for millions. You can raise a fair bit of money to then help you finalize your project, because you promise your investors that if you buy this SAFT, we don't have the protocol ready yet, but once we mint some tokens and we go through the token generation event, you will get a percentage of those tokens if you give us money now. So it's very good for early stage funding. The alternative here is SAFE, simple agreement for future equity. And that would be if you're raising for a company and using and selling shares rather than tokens. And you can do the same thing. Basically, you say, we don't have a valuation yet. We don't know how much our company is worth. But if you give us $100,000 now, in the future, if we raise more money, we will give you shares with a discount, for example. So you'll get a 20% discount compared to what the other new investors are getting, because you trusted us first, you gave us money before everybody else. And SAFE is originally an American invention, but there are no alternatives for Canada, for Singapore, for other jurisdictions. I think that the principles can be taken and applied to many other types of companies. I've seen some for BVI and Caymans as well, so it's now quite a universal instrument that you can use. And then, of course, these are the instruments where you're selling your future rights. But what you can do is do a classic sale where you're either selling tokens to professional investors, or doing some sort of a public ITO, ICO, just a public sale of tokens, or of course doing a prize round where you're selling your shares. So you have a lot of different options. Just before, when you need to raise money, before you do that, stop and think and decide what's the best for your project, just to make sure that you don't give out rights that you wouldn't want to, and that you get the maximum. So just based on this, there are a few types of investors that you can be considering as well. So there's grant programs. Thank you to Cardano Catalyst for giving us the opportunity to be here, to supporting projects. Like, this is a great sort of source of funding for the early stages. But then if you want to continue the project, you can either work with a venture capital fund, and that would either be a more traditional VC fund, so someone who does normal startups and does a bit of crypto on the side, or you could be looking at this very specific, a crypto-specific VC that will be happy to take on pure tokens rather than looking at shares, and that specifies at working with crypto companies. And then you could be looking at strategic investors, so working with an exchange, for example. Like if you're developing something that's useful to an exchange, you can do that. And of course, you can sell to the public. A note here, it's very common in the industry to sell tokens to public and to public crypto offerings. This is heavily regulated, can be very difficult. So do be careful here and make sure that you comply with any regulation here. And then happy to answer questions about this. Talk about this later. It's interesting. And then finally, talking about the key mechanics for fundraising. So there's a lot of things that you should follow. There's a lot of legal compliance, but the number one advice that I can give you is maintaining clear token and equity cap tables and structures. You can start with a Google Sheet, for example, but do make sure that you know how many shares you have, how many tokens you have, or how many of those you promised to issue in the future to different people. You have this written down. You know who's supposed to get what value that has. Like having this clarity is extremely important for you, especially in the early stages before you move on to like sophisticated systems that take care of this for you. So just do know that you promised this and that founder this. You yourself should have this many tokens. You want to reserve something for your future team. So you reserve this much. Then this means that you have this much for your public token launch, for example. But maybe you want to save something for your sort of professional private investors in the earlier round. So you have to calculate with that. So just to make sure that you have this nicely written down, you have an overview of this. And then so the final thing that I wanted to go through and just to have you look at is an example of a simple term sheet. So this is I modified this to be a mix between a classic sort of equity financing style term sheet and a token term sheet. So this is something that you could see for like a blended company, where whenever you're thinking about taking money from someone, open up a simple term sheet template. And for example, you can even use something that's created for purely off-chain companies, but it's very difficult to find quality token-based term sheets. But you can do a simple Y Combinator term sheet and just go through the categories. Think about, okay, do I have a company? Which company is it actually that's selling the shares? Because I want to make sure that it's not me who's personally responsible. It's a company. What am I selling? Am I selling securities? Am I selling stock? Or am I selling tokens or token rights, warrants, SAFTs? What am I selling? How much are people giving me and what they're getting in return? What's my valuation? What's the price per token that I'm offering? Just do think through these things, and you can get into the more technical things. For example, voting rights. Like, I'm giving shares or tokens to my investors. Do they get specific veto rights? For example, the investor could ask, well, I'm taking 1 million tokens from your protocol, but I want to have a veto right on increasing the maximum cap of tokens that you can create and issue, because I don't want you to dilute me and just issue a lot more tokens yourselves. So you can really play around with this, but just do have a look at these different categories and go one by one and try to understand what rights you are giving your investor and what rights you're retaining and what you're getting in return. Just go through a simple term sheet template. Happy to share something like this afterwards if there's interest. And just think about all of these categories before you sell anything to anyone. Because once you sell your tokens or your shares, there's usually no way of getting back. So do make sure you think before that. And so now, if we have any questions, happy to answer anything. Or if you're watching this from a recording, then this is us, the speakers, and our contact details. So happy to answer any questions. Feel free to get in touch. I don't think I see the chat here. So Andre, if you're here, feel free to let me know if there's anything.
There currently aren't any questions. We can give it a few more seconds.
Yeah, happy to give a few seconds, but given that most people are probably watching from a recording due to the unfortunate time zone situation, then happy to get connected later.
Yes, probably. I think we can wrap it up. This was very fruitful webinar, at least from my point. Hopefully, it will bring fruit as well to the others who are watching us online or later from streaming. Yeah, go ahead, Macho, if you can wrap this whole session.
Yeah, so really thank you for listening to us, and please, think about what you're doing. It's not rocket science, it's just about human relationships. So just think about how you want to set them up, and feel free to reach out if there's anything.
Yeah, protect your IP. It was a pleasure.
Goodbye, everybody.
Goodbye.
Okay, thank you very much. Then that's it, and hopefully we'll see each other during the next session. That will be the third one and the last one in the Decoding Legal webinar series. We don't yet know who will come to us later in 2 weeks, but today the presenters and the hosts were Macia Bacikova and Macia Repka. Thank you very much. Woo!
Thank you.
Thank you.